Hello, everyone, and welcome to this session on EU Digital Privacy Act, meaning the general data protection regulation in the European Union, and which has been quite influential across not just the European Union, but beyond. And ODR, we are going to look in particular at the context of consumer dispute resolution, because we have a legal framework in European Union dealing with these issues. And in today's session, we're going to start with Dr. Constantina Sampani, who is an associate professor at the University of Leicester in England. She's a colleague of mine. And she, before becoming a professor at this university, she was a practicing lawyer in Greece, I believe, and she specialized in commercial and maritime law. And then she embarked her academic career as a full-time academic at Aberystwyth University. She has also worked at the Bournemouth University. And her primary area of research looks at the impact of culture in the regulation of extrajudicial mechanisms of dispute resolution, including, of course, the design of ODR processes. So without further ado, I will let Constantina to present her paper.
Thank you very much for having me today. It's an honor to be invited to give this presentation. And without further ado, I will share my screen. If I could have just 1 second, please, to share my slides. I hope they're now visible. Yeah.
Yes, we can see them very well.
Excellent, thank you very much. So the focus of my presentation today will be on the significance of culture in ODR and how it ought to inform the deliberations and design of ODR regulation. One of the core issues that has occurred in relation to regulating online dispute resolution is that this process not only crosses borders, it also moves across various stakeholders, state, non-state, private actors, etc. Also, the contemporary global governance that the use of online platforms requires is a field of competing institutional schemes, interests, legal cultural traits, and systems of rules. Against this globalized, multi-level, multi-centered regulatory backdrop, the question that I would like to explore is whether it is feasible to adopt a common technological and regulatory framework which can capture more informed and finely nuanced intercultural communications. My argument is that a regulatory framework with a cosmopolitan and legal pluralism approach would instill greater trust and confidence to the use of ODR and enhance access to justice, as it will provide a common platform of reference for the various stakeholders involved in its development. For the reasons I mentioned before, the nature of the ODR framework is normative and legal hybrid, and hence it presents a great opportunity to extend contemporary research to consider commonalities across and between national, regional, and global levels of governance when regulating for ODR. The significance of culture in online dispute resolution has been discussed extensively in an invaluable existing body of literature. Examples of the focal points of this literature are the impact of culture in the design of online platforms for dispute resolution, or the export of Western ADR processes to other parts of the world, partly due to the use or encouragement of the use of technological platforms with Western cultural traits imprinted in the software code. The challenges of cultural difference have been inherent to cross-border commerce and dispute resolution since its birth. What ODR brings with it is the resources of the network to the process of dispute resolution and the actors and institutions that govern it. The new global regulatory architecture emerges from both public and private sources, which is an attestation that the old forms of governance do not respond adequately to today's international regulatory challenges. My aim, therefore, is to extend the scope of this discussion beyond the domain of parties' dispute resolution and to extrapolate it to the level of setting standards and regulations as an outcome of the consensus of conflicting interests between public and private actors and the amalgamation of cultures that these actors bring with them at the table of negotiation for regulation. ODR has become an established topic in the policymakers' agenda. The European Union and the United Nations Commission on International Trade Law have issued proposals and initiated rigorous deliberations amongst various stakeholders with the aim to create ODR rules which are culturally inclusive, incorporate the needs of different countries and non-state actors, and reflect a balance of interests between these stakeholders. Under the provisions of the EU ODR regulation, the Commission establishes and maintains a European, and I add emphasis to the word European ODR platform. The term European here deserves the attention. Does the regulatory vision refer to the geographical region of Europe within which the disputes arise and are resolved? Or is the European ODR platform envisaged to reflect the cultural diversity of horizontal, vertical, and across levels of state and non-state arrangements within the landscape of ODR in the European Union? The 2018 ADR Assembly brought together a wide range of stakeholders, representatives of notified European ADR entities, European consumer centers, business representatives, regulators, and academics, amongst others, to promote the deliberations between different stakeholders, the creation and development of networks, and the exchange of best practices. The Commission also conducted communication campaigns in 2016, 17, and 18, and offered a training law ready for SMEs on consumer law. The ODR platform is a multilingual website that allows consumers to submit their claim against the business for online purchases, domestic and cross-border. The regulation also applies when a trader raises a claim against the consumer insofar as the member state of the consumer's habitual residence allows dispute resolution through an ADR entity. The Commission's report also acknowledges the diversity of national ADR landscapes as this is manifested in differences regarding national competent authorities for ADR, established ADR culture or lack of it, certification procedures, and monitoring practices amongst member states. These examples demonstrate the aspiration and vision of the EU to create the regulatory and practical means for more democratic, culturally inclusive dispute resolution. In shaping a culturally inclusive regulatory framework that reflects consensus and hence promotes legitimacy amongst its various stakeholders, the question that emerges is it feasible for the prevailing elements of the national legal systems and cultures and the needs of EU member states in various stages of development and historical and political experiences to be reflected in a single, coherent, and consistent ODR regulatory framework? In this quest, one cannot adopt an oversimplified approach. European states contain a wide range of divergent and subtle hues of social and political structure, historical experiences, legal culture, and attitudes to dispute resolution, and the use of technological platforms for dispute resolution. The difficulty involved in developing a culturally inclusive framework is the risk of being misled by the assumption that the aterritorial nature of technology or the perception of a united European identity results to homogeneity. The out-of-court dispute resolution landscapes in EU member states are highly diverse and their availability unevenly distributed geographically and across sectors. The perceptions of the extrajudicial dispute resolution have also been diverse. The European Commission's report comments that member states can roughly be clustered in those which had a highly developed pre-existing ADR culture, such as, for instance, Finland, and no significant changes in the perception of ADR, a pre-existing but incomplete ADR culture with a trend to further embrace and develop ADR, such as, for instance, Germany, and no pre-existing ADR culture, such as, for instance, Slovenia, where the ADR uptake moves at a lower pace. In light of the ODR regulation, this remark can be extended to include the impact of pre-existing culture in regards to the use of technological platforms for dispute resolution. The observation regarding these diverse landscapes of dispute resolution poses further questions. Is the ODR process suitably aligned with the legal traditions of all member states, or insights into legal cultural issues and subtleties would have a considerable impact on the construction of a culturally inclusive ODR regulation? Is the level of familiarity, skills, and access to technology for dispute resolution evenly spread amongst EU member states? Or has the predominant priority of the ODR regulation to increase the volume of consumers to buy and traders to sell from other member states implicitly favored the traditionally powerful actors? Has the complexity of membership in governance, group boundaries, power dynamics within social and professional groups been taken into consideration in shaping culturally inclusive ODR regulation? My argument is that the cultural analysis of deliberations, rules, and regulations by empirical research can be the avenue in gaining an in-depth understanding of how regulations operate as norms that reflect and respond to social reality. Policymakers can acquire a more nuanced understanding of the EU and transnational terrain by devoting attention to the normative and legal hybrid that is constructed by multiple communities, whether these communities are geographical, national, ethnic, cultural, or epistemic. The proposition is that this alternative jurisprudence will be developed on a combination of both cosmopolitanism and legal pluralism. Cosmopolitan as a framework that recognizes the membership of multiple communities, local, territorial, and epistemic, in shaping and governing norms. Legal pluralist in exploring the myriad ways in which overlapping legal systems interact with each other, and their multiplicity can create debate, resistance, or creative adaptations. Future empirical research through interviews, case studies, and surveys is envisaged to test organization and professional culture and perceptions of policymakers when they are tasked with the regulation for ODR. The same methodological avenues can be used to offer insights into which aspects of the regulatory process the policymakers, state and non-state actors consider to not fairly reflect their cultural perspectives or interests. Or has the intended bridge between policymakers and end receivers been achieved in creating a wider and fair access to justice through ODR? If not, why? Establishing fora with representatives from member states, non-governmental actors, private actors, and end users, including consumers, so that they can exchange views on the operation of ODR as parallel to the formal procedures will inform policymakers and their reactions. This practice would aim to shed light into whether regulation is reflective of power balance and culturally inclusive strategies, and how, and if not, why. This will shift pragmatism in ODR regulation to increase transactions between consumers and trainers into an ethical paradigm of cosmopolitanism through inclusion and democracy, as these are the imprinted fundamental values in the rhetoric of the European Union. Thank you.
Thank you, Constantina. Very, very interesting presentation. And thank you also for keeping to the time allocated. And actually, I think we have maybe time for one question. I did notice, you see in the chat that Dan Rainey posted a question, interesting question. Unless Daniel would like, Dan would like to read it. I can read it for you.
No,
yeah,
I'm happy to say it out loud.
Thank you.
Normally, when we talk about cultural differences in ODR, the usual conversation is cultural differences between the US, where much of the technology develops, and other countries. And my question from your point of view is the issue of cultural differences equally important within the EU, or is there more uniformity of culture across the EU?
Yes, thank you. Yes, I think it is equally important in the EU. And indeed, although it appears that we have perhaps a united European identity, the member states of the EU have such diverse political, historical experiences, and also different approaches in how they resolve their disputes. For instance, with certain EU member states, the patterns seem to be more consensual, the others are more adjudicative, or in other member states we have more mandatory approaches in resolving the disputes out of the court or through ODR, whereas in others the approach is more optional. So certainly the diversity is present and certainly worth considering when shaping or perhaps reconsidering ODR regulation. And I don't know whether this has responded to your question.
Yes, very well. Thank you. I appreciate it.
Thank you.
Yeah, thank you. Yeah, if I may add, I think in some ways there are some fields where there is a close, is more closely aligned European law with the approach in the US, especially with some member states. Like, but on the other hand, we have certain uniformity within the EU, like in terms of, for instance, in the context of consumer dispute resolution, you know, the approach to arbitration in particular, it's very uniform in the EU, where parties have to agree to go to arbitration after the dispute arises. And, you know, this has been a bone of contention in the UNCITRAL discussions, where the EU had a very, very different approach to the US in terms of pre-dispute arbitration clauses in the context of consumer dispute resolution. So I think in the European, you know, there are a movement towards this convergence in the approach that, you know, as Constantina rightly said, that it should be sensitive to the diversity, the great diversity that there is within the European Union and generally with ODR beyond the European Union. Yeah,
I'm sorry to take up time, but I'm kind of curious, is the movement toward uniformity based on arbitration more than mediation, because arbitration is a quasi-legal approach as opposed to a more open approach for mediation?
Yeah, I think it's not exclusive to arbitration. It's certainly the European framework on consumer ODR. It tries to embrace the variety of processes, so includes mediation, arbitration, ombudsman, complaint boards, the different type of processes. And we do have already, you know, a mediation directive. So there is already some uniformity in terms of these processes, in terms of arbitration and mediation. And interestingly, in the context of mediation, the ODR directive requires that when a settlement proposal is put forward, that the consumer has the ability to have a cooling off period. So, request for some time in order to consider that proposed settlement, and even, to explore legal advice if the consumer wants to do so. So there is a movement towards, developing these rules in the context of consumer dispute resolution in the European Union, and not just to arbitration, but also to consensual dispute resolution mechanisms.
Thank you.
If I may, I'd like to move on to the second paper, which is the one I am going to present, and that also continues well with the discussion that started by Constantina about the European approach to consumer ODR. If you like to, I can introduce myself briefly. I'm a professor in civil justice at the University of Leicester, same institution as Constantina. I've been here for the last 14 years. I'm originally from Spain, where I study law, and I study for an LLM and my PhD in Ireland. And my research has focused mostly in the context of consumer ODR over the last few years. I published a couple of books in this field. And I also work part-time as arbitrator, adjudicator for CEDAR, which is one of the main ODR, ADR providers in the UK and in Europe. And I resolve hundreds of disputes, mostly airline complaints against airlines, telecommunication providers, water retailers, and even I had a case, Amazon dispute between the business and Amazon, the marketplace. And all these processes, they're actually pretty similar. They are mostly adjudication. They fall within the European framework of ADR and ODR, even after the UK exit the European Union. So let me give you a bit of context about the European legal framework, which is basically a directive and a regulation. The two legal instruments are interlinked, and they have the aims of increasing access to justice for consumers, for European consumers, and promoting cross-border trade and the digital market in particular within the European Union. So the directive, which is the most important legal instrument, tried to tackle three issues that were perceived to hamper the development of ODR and consumer ADR in the European Union. And that was that, in first instance, in some, the availability of ADR up until before the legislation was quite patchy. So in some European countries, there were ADR bodies dealing with consumer issues. In others, they were not. And often when they were available, there were gaps in specific economic sectors. So in first instance, the ADR directive requires all the European countries to ensure that they have ADR bodies and ODR bodies that deal with virtually all type of consumer disputes between consumers and merchants and traders. The second issue, the second problem that the legislation tried to address is that when there were available ODR bodies and ADR schemes, the quality and independence of these bodies, they vary from one scheme to another, from one provider to another. So the European legislation set procedural standards or legal standards or quality standards, if you like, for those ODR bodies that are certified. And these are certified now by public authorities or competent authorities, which are public administrative bodies. Typically, they operate in, they are regulators of the specific sectors. And this quality assurance that now it's embedded in the European framework requires these bodies, these ODR bodies, to be independent, impartial, to be accessible and provide fair processes, meaning that it should be free for the consumer or at a low cost. It should resolve dispute in a maximum of 90 days. As I mentioned earlier, if there is a proposed settlement, the consumer should have the ability to seek advice, have some time to consider that settlement proposal, and so on. So you have this quality criteria for those ODR bodies and ADR bodies that are publicly certified by so-called competent authorities for these public bodies. The third and final issue that the European legislation seeks to address is the lack of awareness. So even though the vast majority of consumers and traders and business prefer to use ODR and ADR before going to court, in most cases, they are not aware about their existence. So what the directive does is requires all traders in the European Union to inform consumers about these ODR and ADR bodies that have been certified for complying with this quality criteria. Now, the downside is that they are not required to participate in these processes unless the national law requires them to do that. And that happens often in regulated sectors like utilities, financial services, and so on. The regulation, the ODR regulation, complements the directive and also tries to increase awareness and online access to these ADR processes by setting up what it is called an ODR platform, which is basically a website where consumers can submit complaints against traders on issues related to online disputes, so e-commerce claims, basically. And if they cannot reach a settlement between, sending the complaint directly to the business, then the platform will help them to identify an ADR and ODR body that will resolve the dispute. And these are the ODR and ADR bodies that have been publicly certified. You have at the bottom the link to the European platform. And you have there a screenshot of the European platform, and at the top, a book that I edited a few years ago, where we look at the implementation of the European framework in different European countries. So the European Commission has published data about the operation of the platform during its first years of operation, which started operating in February 2016. By then, it had received just over 100,000 claims, which is a very modest number for the size of the European Union, where you have around 500 million consumers. And there was only a tiny percentage of these cases, around 400 cases per year, that were referred to a certified ADR entity, or an ODR body. So when parties cannot reach a settlement, parties can agree to send it to an ADR and ODR body. The platform has received many visits, like 2 million visitors per annum, per year. And this is because all traders operating online in the European Union are legally required to have a link to the ODR platform. So when consumers have complaints, they can use the platform to send the complaint. They deal with both domestic as well as cross-border issues. Currently, there are, I think, the most recent data is around 52 or 53% domestic issues and around 47, 48 cross-border. When you start operating, was mostly domestic issues, was around 65%. So increasingly it's being used for cross-border issues. And the platform also leads to access to have more to more than 400, to around 400 ADR and ODR bodies. But the main problem with the platform is that if the business do not reply to the consumer complaint, the case is automatically closed after 30 days, and that happens to 85% of cases. Most of the remaining cases are also closed because the trader refused the complaint or one of the parties withdraw the complaint. Only around 2% of the cases are referred to a certified ADR or ODR body. The Commission claims that around 40% of the overall cases, they settle. So once the business or the trader receives the complaint, they respond to the consumer, but outside the platform. So there is, the Commission claims that there is a significant number of settlements as a result of complaints submitted via the platform. And in that recognition led to some changes. Last year, the Commission created a sort of a parallel platform that they call the self-test tool, which allows the consumer to communicate directly with the trader. So basically, it's they call it direct talks, and it's an online negotiation platform where they are not restricted to the 30 days set in the regulation. And also consumers could also contact European consumer centers that assist consumers with cross-border disputes, or they could contact directly an ADR entity on ODR body, and this may be helpful for those cases where the traders are legally required or contractually required to participate in ODR or ADR process. So for instance, as I mentioned earlier, issues related to utilities and financial services, or complaints against banks and insurance companies that often ADR bodies where the traders are legally required to participate. In addition, the Commission is also providing information on consumer rights on the most common type of issues. However, this is not a proper triage or self-diagnosis system. Maybe that will be the next step. And another change, which it's been proven effective, is that traders can register in advance in the European ODR platform, which allows for the consumer, when they made a complaint, to have all the relevant information from the trader in advance. So, and it'd be important to get the relevant information, especially the email address of the trader. And also this avoids from complaints being sent to the junk folder of the trader. So moving on to whether the European law has been successful. I want now to look at whether the aims and goals have been realized. So has it increased access to justice? Well, not by much, because it's not used that much, but it has led to changes at domestic level, and increasingly countries like Portugal and the UK have made it mandatory for traders to participate in these ADR processes. So insofar as I believe that after the European regulation, consumers have greater access to ADR and ODR bodies. So it has contributed to increase access to justice, but in a modest manner. In terms of promoting trade, I think this is a more problematic, because in order to promote trade by using ODR, you would presume that consumers will choose traders or businesses based on whether they or not they are adhered to an ODR body, based on whether they provide that additional guarantee that if a problem arises, an independent ODR provider will look at it and provide redress when relevant. So moving more specifically to the goals, now we have a full coverage. So in the European Union, you can find ADR bodies dealing, mostly operating online, that deal with all type of consumer issues. But the main problem, and also this is quite confusing for consumers, is that participation can be optional for the trader. And this depends on the European country and also often on the sector they operate. So yeah, there is better coverage than before, but insofar as the participation is optional, often consumers may not find an ODR or an ADR redress available to them when the business refuses to participate, which is more common in non-regulated sectors like traditional retail or e-commerce for the matter. In terms of the minimum quality standards, I think this has been achieved, although the level of supervision and how it is monitored by competent authorities would vary from country to country, and it may be sometimes quite light touch, but certainly at least we have now a minimum criteria of the standards of due process of quality standards. So I think that there has been an improvement in that sense. Finally, in the terms of increasing awareness, there is more awareness now about these processes, partly because the businesses are required to inform about them. But there is a problem when the trader does not participate in the process, and then it undermines trust on ODR and dispute resolution when the consumer is unable to resolve the dispute because the trader refuses to participate. Currently, and with this I finished, the European Commission is considering to amend the European legal framework, and it has issued a public consultation that is open to everyone to do. You need to register in advance. Here is the link. There are a number of issues that I have identified, partly because I also collaborated with a consultancy who is doing a empirical research project for the European Commission to where it is looking how effective has been the implementation of European legislation. So the European, in terms of the ODR regulation, the European Commission is considering whether to change it or to scrap it altogether, because they say, well, for such a small number of cases that are referred to ADR entities, it does not, the fact that most cases are left without a response from the trader, maybe they want to change it to what the ODR community would call it a clearinghouse. So a website that signposts users to certified ADR and ODR entities. Currently, under the regulation, it requires that both parties agree to use an ADR entity before the case it is referred via the ODR platform. So this may not be longer a requirement under the amended legislation. Also, national portals seem to have been very effective. So basically, like the European platform, but at a national level. So that may be promoted. The same for the trader's obligation to reply to complaints, because currently, as I mentioned earlier, in most cases they do not reply. They're also looking at increasing the voluntary scope of the ODR platform, which currently only applies to the European Union. They are looking to include also non-European and offline disputes, but on a voluntary basis. In terms of the ADR directive, there is also a discussion on whether to increase the scope to include complaints made by businesses against consumers, and to also include unfair commercial practices. Also, they are looking at making the certification of ADR entities mandatory, which some countries like Portugal have already done, and the UK is considering doing. They also want to clarify the protection of vulnerable consumers and the implications of artificial intelligence and automated processes, whether this could be certified as ADR entities. And they probably set out a criteria, and one of these will be requiring human review for their decisions. They are also looking at strengthening the standards of independence and the information requirements that are those that businesses need to notify consumers about, about the ODR platform and ADR entities. But they are not required to participate. So this is leading currently to some confusion. So there is some discussion about how to improve, how to change this in a way that the consumer is better informed and is not misled about the availability of ODR and ADR processes. So with that, I'll stop my presentation, and if you have questions, I'm happy to address at the end of this session to leave enough time also for Fernando to present. Let me stop sharing my screen. Okay, Fernando, can you upload your PowerPoint?
Okay. Thank you very much, Pablo, for your presentation. Thank you for inviting me to present today in this contribution of the Cyberweek. It is a pleasure to be here. I'm going to try to put my presentation.
While you upload your presentation, I can do a very brief introduction of Fernando, who is a professor at University of Granada. He has a chair in private international law. He's the secretary of the comparative law seminar at his university, as well as the secretary of the academic commission of international network in private and integration law. He's a fellow of the National Center for Information Technology and Dispute Resolution, a fellow of the European Law Institute, a member of the editorial board of two prestigious journals in Spain on private international law and European law. He has published extensively in the field of ADR and ODR. Most recently, he chaired the development of guidelines for digital justice, which was funded by the Cortes Foundation. It's a very prestigious foundation in Spain that was presented in the findings of this foundation by the King very recently, and he has been involved in many other projects, and notably with me, we collaborated with the European Commission, working as consultants in helping them to draft the European proposals for the ODR regulation and the ADR directive. Sorry, without further ado, I'll let you, Fernando, present your paper. Thank you.
Thank you very much, Pablo, for your kindness presenting me. So really, as I was telling you before, it is a real pleasure to be here in the Cyberweek to contribute in the field. And I would like to, so I'm going to speak on the data protection, the personal data protection impact in the field of ODR. This is all the regulations, all the framework we have in the European Union has to respect the personal data protection regulation. The importance of data protection in the European Union is reflected in the inclusion of this right among the fundamental rights. Indeed, the Charter of Fundamental Rights of the European Union declares it in the Article 8. This protection takes place today through the regulation very well known 2016/679 of the European Parliament, of the Council, on the protection of natural persons with regard to the processing of personal data. So my contribution is structured as follows. First, I will make some general remarks on data protection regulation in the European Union and how it affects the functioning of ODR. I will then go on to consider data protection requirements at 3 different points in time. First, before the data processing. Second, during the data processing. And third, an ex-ante perspective of the consequences of data processing. The use of technological tools used in the online resolution of disputes, that is to say in ODR, may generate a number of situations in which personal data processing takes place. The use of data may be very frequent and even inadvertent. To be aware of the impact of the GDPR, it is important to consider that the concept of personal data and the concept of data processing are very, very broad. Personal data means any information relating to an identified or identifiable natural person. Data processing means any operation or set of operations which is performed on personal data. The processing of data is submitted to the principle established by Article 5 of the GDPR. There are lawfulness, fairness, and transparency, limitation of the purpose, minimization of the data, accuracy, limitation of the storage period, integrity and confidentiality, and accountability to ensure that data controllers implement appropriate technical and organizational measures, not only to comply with the regulation, but also to demonstrate compliance to supervisory authorities and data subjects. Different technological tools can be used in ODR. In each of them, it is necessary to ensure compliance with the principles set out in Article 5 of the GDPR. We have electronic file, we have telematic connection and electronic communication, we have electronic communication history, chatbots. For instance, in order to use this kind of tools, the use of biometric data for the operation of some application is currently generating some debate at the European level. It does not appear that biometric or facial recognition is that least invasive method of identification. This is clear from both the European Data Protection Board guidelines from 2019 on processing of personal data through video devices, and the European Data Protection Board and the European Data Protection Supervisor Joint Opinion of 2021 on the proposal for an EU regulation on harmonized rules on artificial intelligence. The EDPB recalls that biometric data are special categories of data and that the principle of lawfulness, necessity, proportionality, and data minimization must be taken into account. We have also the possibility of online courts. Maybe we have to treat with data of minors. And we have also the problem of online publication of judgments and decisions. Related to this, the publicity of judicial decision is a guarantee of democracy and should not be limited by data protection. In assessing which data should be made public, it is necessary to strike a balance between the right to data protection and the right to publicity judicial decisions. On this point, an impact report on the publication of judicial decision should pay particular attention to the proportionality of the processing operations in relation to the purpose, as well as to the risk of the rights and freedoms of data subjects. The starting point of the GDPR related to the personal data protection is that only the data necessary at any given time for each purpose are processed, and that the data is not accessible without the intervention of the individual to an undetermined number of third parties. Accordingly, the controller, the court, or the ODR entity must take appropriate technical and organizational measures to ensure compliance with the GDPR and demonstrate that it does so. This ex-ante plan must at all times take into account the state of the art and the level of risk. Related to the cybersecurity and data processing, the recently published guidelines of the Committee of Ministers of the Council of Europe on online dispute resolution mechanism in civil and administrative court proceedings of 16 June 2021 proclaim the principle of security by design and security by default. Security by design means that all those involved in the design and other platforms implement measures in the early design and develop phases in order to protect the security of these products, services, and processes to the greatest extent possible, so that it is feasible to anticipate the occurrence of cyber attacks. At the same time, security by default means that the ICT tools should be configured to ensure the highest level of security, so that the first user receives a configuration default with the highest possible security settings. But what to ensure? The data must be processed in a way that ensures its security and confidentiality and prevents unauthorized access and use. And the responsible to do that is the controller, and the controller must first assess the risk of the processing and select and implement measures to mitigate them. The main data security risks are accidental or unlawful destruction, loss, or alteration of data, and at the same time, unauthorized communication or access to data, leakage, or a possible resulting damage. In case of breach, the GDPR established that the data controller must alert the competent authority of security breaches within the 72 hours of becoming aware of them. The data subject must also be alerted if the breach poses a risk to his or her rights and freedoms. Related to the ex-ante perspective, since the use of ODR poses a risk of harm affecting the right to data protection, the GDPR requires that these potential risks and harms arising from the processing of data be anticipated in advance of the processing through the so-called impact assessment. The data controller, the judge, the judiciary, or the ODR entity is the responsible of developing the impact assessment. By the way, the GDPR include which is the content for this impact assessment that is obligatory, is mandatory for the controller. Finally, if we talk about data protection and ODR, it is not possible to ignore the obligations deriving from Article 22 GDPR in relation to the use of artificial intelligence tools applied to online procedures, whether in court proceedings or before ODR entities. The importance of this issue raises new challenges, and I would like to highlight it, although it is not directly related to the subject of my contribution. Article 22 of the GDPR provides for the right to human supervision of automated decisions, prohibiting fully automated decisions where they have significant effects concerning him or her, or similarly significantly affects him or her. In line with these general considerations, the guide for e-justice that Pablo mentioned before, that has been presented in Spain last month of May, has proposed a traffic light system, green, yellow, and red light colors, to express the low, medium, or high impact of the use of artificial intelligence tools on the content of Article 22 of the GDPR. For instance, if we are talking about a tool to file a lawsuit through an expert system that requests necessary information and prevent filling of data if data is missing, it would be green light tool. But if we are speaking on the tool to assist for argumentation in the ruling, or to assist to the judge in the evaluation of evidence, that would belong to the yellow color of to the middle risk. If we are talking about a priori assessment of witness credibility, of offering to user a prediction of the outcome or a decision issued by the ODR platform without human intervention, this would belong to the red light traffic lamp to the high risk. So it would be, we had to be, to have a human intervention, and this decision could not be automatic. Thank you very much for your attention. I will be available in case any question related to my contribution. Thanks a lot.
Thank you, Fernando. Well, you only have 1 minute to spare, but if anyone has questions, this is the time.
I don't have any questions, but I did want to congratulate all three of you. Very, very good, very clear presentations. I really appreciate them.
Just one question. This is Jeff Oresti. The question comes up. I'm doing a lot of work with folks in Poland and Ukraine, and there are going to be a lot of disputes that are going to arise as a result of the Ukrainian situation. And people that are leaving the country and coming into the European Union. And of course, the access to courts is going to be very difficult, if not impossible, for many of these people. Has any idea developed about how ODR might facilitate or be used in that kind of a setting to help the access to justice for Ukrainian refugees? Just curious if that has been discussed.
I don't know whether Fernando wants to say something about this. I'm not aware of any specific process to do this. I think they are mostly, this is being done mostly at a domestic level by the member states. And I know it was his name, Petros. There are some ODR software specifically to deal with refugee issues, but I'm not aware of any specific ODR application. What I know though is that in the UK, the Immigration Tribunal is processing claims online, entirely online, dealing with issues of refugees. But these are the courts, not out of court processes. Let's see. So I don't know whether Fernando, you have something you'd like to add?
No, I agree with you. This is a question in domestic law, and the situation I don't think is comparable with the pandemic situation we had during the months that the COVID pushed in the first wave. Because I don't really know how the destruction in Ukraine has impact on in the field of domestic courts. But I think that many of the measures taken during the pandemic situation maybe are also helpful to resolve the problems that now even, but it is difficult to say now that if people has sufficient technological tools and internet connections in order to have virtual hearings, all these things that were very usual during the pandemic. So I'm not in the position to know, but I think that many of the measures that were taken during the pandemic may be of help in the situation that during the war in Ukraine is taking place.
Actually, on the issue of data protection, if I may, something that really surprised me when I was told that if I use CEDAR, the ODR system for dealing with consumer issues outside the EU, and they find out, they'll say they will fire me, because that would be a breach of the GDPR. So, a breach of the data protection. Whether they will find out, I don't know how they could find out, or whether I could hide myself using a VPN that pretending to be a different country. But yeah, these issues of data protection could restrict, obviously, the operation of all your providers.